Hello and welcome to the Tennessee Informer. Thank you all for joining us tonight. Supporters of the Second Amendment in Tennessee, and specifically members of the TFA or GOA, have followed the Hughes versus Lee case and are well aware that Governor Lee and AG's committee are in fact hostile to the right to keep and bear arms in Tennessee. The AG has offered some of the most ridiculous defenses of the intent to go armed clause that's in the Tennessee Code annotated, such as you can't be allowed to carry a handgun because you might carry a hand grenade. And then the more recent, now drunks might wander in the streets with guns if the state is not allowed an emergency stay until the appeal is ruled on. Both are ridiculous, and were not taken serious by the court. I'm starting to see that the AG in Tennessee stands for anti-gun. But many in Tennessee don't quite understand that the case is actually based on violations of the state constitution and prior state Supreme Court decisions. Here to discuss this and to better explain our rights and responsibilities under the state constitution and that of our legislators is Richard Archie, West Tennessee Director of the Tennessee Firearms Association. But first, it's time for the Informer Report. Is it Qatar first now? What happened to America first? The Trump administration recently signed an agreement with Qatar that declared the U.S. shall regard any armed attack on the territory, sovereignty, or critical infrastructure of Qatar as a threat to the peace and safety of the U.S. An attack on Qatar is considered a threat to the security of the U.S., and that in the event of such attack, the U.S. will take all lawful and appropriate measures, including diplomatic, economic, and, if necessary, military, to defend the interest of the U.S. and Qatar. What the hell? So much to unpack here, and I will do my best, but I do encourage you to go to whitehouse.gov and read this for yourself. The first thought is this sounds like a treaty, and my understanding is the president can't make a treaty unilaterally, and the Senate has to approve any treaty. This also ensures that if Iran attacks Qatar, that we will be involved. Before doing this, Trump had Netanyahu apologize for attacking and killing leaders of Hamas that were in Qatar. So you have to wonder about the whole narrative that Israel/Netanyahu controlled Trump. Trump owns this art of the deal maneuver, and this is just the type of entangling alliance George Washington warned against. To make matters worse, Qatar is long known for funding terrorist organizations throughout the world, including Hamas and Al-Qaeda, and the royal family has a close relationship with the Muslim Brotherhood. And don't forget, the Trump administration wants Qatar and the Saudis to invest in America. If they invest in America, you can bet they're going to infest America. How many epic cities will that result in across America? I encourage everyone to read the latest town hall article on Qatar and their long history of terror financing written by Amy Curtis, posted last Friday. Speaking of Islamist doctrine, did you know this is happening here in Tennessee under the new voucher program being pushed by Bill Lee and the establishment? Multiple Islamic schools across the state are now using our tax dollars to fund Islamic schools that promote Sharia law and jihad. Who knew? Well, anybody without crap for brains knew this would happen, but it gets worse. Representative Jody Barrett brought this up during session when he was opposing the voucher bill but was ignored. That means every Republican that voted for this was okay with funding private institutions that promote Sharia law and jihad. That's how pathetic our Republican supermajority is. Full story on that is at the Newman Report, freedomproject.com. The SecDef speech last week was spot on and way overdue. In my opinion, they really need to look hard at anyone promoted during the Obama or Biden years, general officers and admirals and so on, and really the first Trump term since he was so undermined by senior leaders at the time. I do have one major concern, and that's Trump's follow-on speech where he referenced the fight in our cities. Fighting crime in cities is not the purpose of our military. Even rebellions require the legislature or governor to request support. We don't need to get accustomed to the use of the military, including the National Guard, in our cities. The dirty 7th District race. Who is the best candidate for the 7th District seat abandoned by Mark Green? Well, ultimately, the voters will decide tomorrow, and what so far has been a very dirty race, with most of the dirt being slung at State Rep Jody Barrett by outside groups. In a report by 90.3 WPLN, written by Mariana Bacallo, it seems that more than $840,000 has been spent by out-of-state groups against Jody Barrett. The out-of-state PAC School Freedom Fund, a pro-voucher organization, spent $500,000 against Barrett, who opposed vouchers. Only one man is listed as funding the PAC this year, and that is Jeff Yass, a billionaire and one of the richest men in the world. Matt Van Epps, also a leading contender in the race and endorsed by Green after he quit his post, has received more than $500,000, including some from a PAC heavily funded by Jeff Bezos, known as the Patriotic Fund. So the pro-voucher crowd, including the out-of-state funders, are trying to weigh in on our elections. Think about that when you go to vote tomorrow. That should not be allowed at all, in my opinion. That wraps up this installment of the Informer Report. If you have a news story that you want to alert us to, be sure to send us an email at tninformer.tv@gmail.com. Now to our guest, Richard Archie. Hey, thank you for joining us. How are you doing today, Richard?
Well, I'm kind of like y'all. I've been having computer problems as well. So it looks like my voice and lips are going to be a little bit off, and I've tried to adjust it, but not doing too good. So you'll just have to listen instead of look tonight.
It'll be all right. When you speak, they're going to hear you. I guarantee you that. I want to talk a little bit to get this started off. Can you kind of just give, because there's so many people in Tennessee that really know nothing about the Tennessee Constitution, can you give a basic overview of the Declaration of Rights as it applies to the Hughes versus Lee case?
Yeah, the Declaration of Rights is part of the problem that we have now, in that in 1870, they changed from the original construct of the Tennessee Constitution Declaration of Rights, which Second Amendment analog at that point said that the free men of this state have the right to keep and to bear arms for their common defense, period. That was changed in 1870, and now it says the citizens of this state have a right to keep and to bear arms for their common defense, but the legislature shall have power by law to regulate the wearing of arms with a view to prevent crime. Now, there's nothing in the original Constitution or anything in the Constitution of the Union that says anything about legislators being able to gainsay what was the original promise of the Second Amendment, which simply says that the right to keep and bear arms shall not be infringed. And so they put it upon themselves in 1870. And by the way, that was a group of Democrats who were still in charge of the state of Tennessee at the end of the Civil War, and they wanted to be sure that the freed black slaves didn't have any opportunity to bear arms in support of themselves and opposed to the KKK and the Night Riders at that point. And so they wanted to make sure that the freed slaves couldn't own arms, because that would get in the way of them being forced to do whatever government wanted them to do at that point. And then they found out they could use it against the rest of us. And so from 1870 until 1994, there was no opportunity for an individual to carry a handgun lawfully in the state of Tennessee. The only person that could do that would be a post-certified law enforcement officer or a special deputy, which the sheriffs would take money for their campaigns. And if you gave enough, they would then indeed name you a special deputy, and you could at that point carry a handgun in your own county. But it was not until 1994 that it was lawful for any person in the state of Tennessee to go armed. And our statutes now say it is an offense for any person to carry a firearm or a club with the intent to go armed. And so that basically now the statute is a child of that change in our Declaration of Rights from what was arguably a really good set of documents until what we've got now, which is not so much.
Right. But according to the Chancery Court, which, you know, that's not just your traditional Chancery Court, is it? The court that the case went through?
Yeah, it is not. What this is in fact a duly constituted three-judge panel, which under the statutes of the General Assembly, once again, remember, this is the thing that's important. Only the legislature can make laws.
Right.
And so they changed up in 2012, I think, and said that you can't have just a single justice, judge, chancellor, or circuit court judge hear a constitutional issue in Tennessee. It has to be a three-judge panel, and you carry it to any one of these courts, chancery or circuit court. And then, if in fact you call to challenge a constitutional status on a statute, then it has to go before a three-judge panel, and the Supreme Court of Tennessee appoints the other two justices. In this case, in the Hughes v. Lee case, Michael Mansfield, who is the chancellor in Gibson County, where the plaintiffs brought the suit along with GOA and GOA Foundation, they brought it there, and then the Supreme Court appointed two circuit court judges from across the state to join in with Chancellor Mansfield to hear the case. Now, a couple of things occurred. We asked originally for an injunction in this, and then the state came back and said a chancery court can't issue an injunction. And the chancellors came back and said that's correct. So we changed our pleading from asking for an injunction to just simply a declaratory judgment, which, by the way, any chancellor in the state of Tennessee can issue. And so therefore, we simply read their book and played by their rules, and we went back and asked for a declaratory ruling. And in that, we just simply asked to set aside the intent to go armed clause of the statute, and then the Parks statute itself, which is 3917 1311A, which says you have to have an enhanced carry permit to be able to carry a handgun, because you can't carry a rifle or a shotgun in Tennessee except to hunt. That's a crime. It wasn't until 1989, but it is now, because I perceive that the General Assembly wants to be sure that we're as disarmed as possible. They intend to do stuff that would make you maybe want to use those firearms. Right. And so therefore they've made it illegal to do so in 1989. That doesn't comport with Bruen, that says if in fact a person's conduct implicates the Second Amendment, then the burden shifts instantly to government to prove that its infringement on those natural rights comports with historical tradition from the time of the founding. Well, 1796 is the time of the founding for Tennessee, and in that instance, the Second Amendment analog said the free men of this state have the right to keep and to bear arms for their common defense. And it doesn't specify handguns or rifles or shotguns. It says arms. Right. And so that's hatchets, bulldozers, Stinger missiles, anything you might use to provide for your own safety, depending on what the need arises at that point. You go back to Heller, and it describes arms. It's anything that a man can pick up and hold in his hand to use to strike at another in offense or defense. So if in fact that is the definition of arms under Heller, then it's the definition of arms for Tennessee now. But I hadn't seen any of our legislators rushing and filing bills and talking to Attorney General to come in and say, yeah, he's for it, or the governor to say, yeah, I approve this message. So none of them have done that. So it's just a simple situation that they're pretty happy with the fact that they've got the power to regulate arms with a view to prevent crime. Of course, by the way, now, I've never seen them ever bring to testimony in any committee anywhere showing that any of the things that they've got on the books actually reduce crime. In fact, I've had legislators ask them, what laws do you enforce that keep a criminal from using a firearm to commit a crime? And, you know, they've never given me an answer.
What do they say? They just ignored the question?
Well, no, what they do is they say, well, you know, we've got this handgun carry permit deal to make sure that only those people who are lawful can carry. No. See, because right now you got criminals, felons in possession and all of that. You're not enforcing any laws that keep criminals from using guns to commit crimes. Right. There are none, because criminals don't pay any attention to any laws. The only people that are going to pay the vig for the enhanced carry permit are lawful gun owners and people who want to obey the law. The criminals are not going to do that.
Right. Just to clarify, though, this case, Hughes v. Lee, I know you mentioned Heller and Bruen and others, but this case at this point is just all based on state constitution, and obviously the prior state Supreme Court opinions are going to figure in as well, correct?
Well, no, that's not necessarily true, because in the order from the court, what they do is they mention this one, it's your favorite thing that I say, is that in 2010 in McDonald v. City of Chicago, the Second Amendment of the federal Constitution was incorporated against the states through the Due Process Clause of the 14th Amendment, which in effect makes any attempt by any person anywhere, whether they're the governor, the attorney general, a sheriff, police chief, deputy, it doesn't make any difference. If they violate the tenets of the Second Amendment, they are in fact committing a violation of federal civil rights. And so they're opening themselves up to lawsuits for that. The three-judge panel did two things. It said that the intent to go armed clause or statute in Tennessee was unconstitutional. Then it also said that the park statute was unconstitutional. They didn't change any of the other criminal codes anywhere at all. They didn't say a drunk person can carry a shotgun down the middle of the street and terrify other people. That's still against the law. And so we didn't touch those statutes with what the Mansfield court ordered. It just simply said that you people are wrong on this and you need to go back and fix it. These are unconstitutional. And so they came up with all this mess about, well, you know, we're going to be able to convict you of a crime if you carry a hand grenade in a park. That's the most ludicrous thing I have ever seen. Because by the same token, they would say, we can convict you of carrying a battleship or a case of dynamite. Because in their code section that they use to describe firearms in Tennessee, the General Assembly has included all of those things. Destructive devices and Stinger missiles and atomic bombs, all those things are included as firearms in Tennessee, which is silly, if you want to know the truth.
But the legislature did that. They created that scenario.
The legislature has done that. Okay. That's correct.
But back to my point, I mean, the violation at this point, I understand that you can take it and do a federal civil right, but at this point, they found that it's a violation of the Tennessee Constitution.
That is correct.
And past state Supreme Court opinions, correct?
That's correct. The most important one of those is, in fact, Andrews v. State, which on several different instances says, you know what you can't do? You can't tell a man that he can't carry a firearm. And it, like it says, is what then is protected in the right to keep and thus use. Not everything that may be useful for offense or defense, but what may properly be included or understood under the title of arms, taking connection with the fact that the citizen is to keep them as a citizen. Such then are found to make up the usual arms of the citizen of the country, and the use of which will properly train and render him efficient in defense of his own liberties as well as the state. Under this head, with the knowledge of the habits of our people and of the arms in use of which a soldier should be trained, we would hold that the rifle of all descriptions, the shotgun, the musket, and repeater are such arms, and that under the Constitution the right to keep such arms cannot be infringed or forbidden by the legislature. And that came out, that's Andrews v. State, in 1871. That is a Supreme Court ruling in Tennessee, and I've heard a number of people say, well, the order from the Hughes v. Lee case, we need to go ahead and get a higher court to say that so. Well, no, we actually sued the governor and the attorney general, and the order of the court specifically said it was statewide. And so well-meaning individuals who think they understand the game and who do not by any stretch of the imagination said that we needed to go ahead and appeal this, which the general acumen of the state Supreme Court and the attorney general and the appellate court, by the way, is to always kill a constitutional challenge in any procedural way that they can without ever discussing the merits of the case. Yep. And so what they're doing right now, any person says, oh, we need to appeal it to make it better, is falsely one of two things. He either intentionally knows that he's killing the order of the court, or he wants to be sure that it gets done and everybody's hands are clean.
Yeah, yeah. I can't believe that anybody would think that let's appeal it. That the side that was losing their right would say and the court awarded and the court said, yeah, you guys are right. Why would you want to? You stop while you're ahead. Why would you want to do that? Why would you want to appeal?
Well, actually, there is precedent for doing that very thing from a federal court order that came down to the state of Tennessee 2 years ago in the Beeler v. Jeff Long case, where individuals who are 18 to 20 years old sued the state and said, we literally think that if we can be forced to carry a firearm in defense of the state, we should be allowed to carry a firearm in defense of ourselves. And so that court case went through several years, and the attorney general at that point just kept putting it off and asking for extensions on it. And finally, when Jonathan Skrmetti came in, he said, hey, wait, I'm not going to defend the state against this. The challenge scheme of the state of Tennessee denying 18 to 20-year-olds the ability to carry a handgun to protect themselves or to perfect permits to do the same is a violation of the 14th and Second Amendments, which made anything to do with the Second Amendment in Tennessee a civil right. Now, you and I have talked before offline about the fact that the only thing that the state of Tennessee is willing to nullify from the federal government is just simply the Second Amendment.
Yep. Yeah, absolutely. They told Skrmetti on the notification bill, said, oh, hey, you can't, federal government is supreme and Supreme Court's the final arbiter. Now, obviously, I think that's a crock, but that's what he said. He said that less than 2 years ago. So just on the face of it, and then when you take into consideration and what he said in that case you just mentioned about the 18 to 20-year-olds, I don't even know why Hughes v. Lee, I don't even know why it went anywhere. I don't know why he didn't, just being consistent, look at it and say, yeah, I'm not going to defend this. But So he's doing the governor's bidding. That's exactly what he's doing. But I don't understand it.
It's further than that, Dave. People think that the Attorney General of the state of Tennessee represents the people, but he does not. He represents the state. And his only job is to make sure that the statutes as they stand today are protected and the Constitution as it stands today is protected. You know that I, for the last 2 years, with Jay Reedy's help, have run a constitutional amendment that would change the construct of our Declaration of Rights with respect to the Second Amendment analog and simply carry it back to the original construct that would now say the citizens of this state have the right to keep, bear, and wear arms, period.
Right.
Now, I actually got it passed through the Senate 2 years ago, and when it came to the House, it was killed outright. They didn't even let Jay Reedy put it on notice. And what they do in the House is they say, oh, well, it will have to go on the ballot statewide in a year that there's a governor's race. Right. And so there's a fiscal note of $5,000 on it. And so when it goes to finance, they kill it and say, we just don't have enough money. When they're giving billions to Ford and to the Titans. I don't understand why they don't have $5,000 out of that budget, or the governor say, hey, I'm going to put it in my budget to get that done. But it simply means that what we have is a legislature that wants to keep its foot on the neck of liberty in Tennessee.
Right. But back to the AG, though, but he still takes an oath to uphold the Constitution, right?
He does. Every person that takes a position of profit or trust, whether elected or appointed, shall, before they proceed to business, take an oath to defend. Here we go. Before entering on the duties thereof, take an oath to support the Constitution of this state and of the United States, and an oath of office. So the oath of office then is actually their job description, but before they get to that, they have to promise to support and defend the Constitution of this state and of the United States. And it doesn't make any difference what your job description is, whether you're the dog catcher or the governor, you still have to uphold the constitutions. And so if you look at the Second Amendment, it says that government shall not infringe the people's ability to keep and bear arms.
Right.
It's just that simple. And how anybody could parse it a different way is beyond my capacity to understand.
So when they made the change to the Constitution in 1870, and they made the reference, regulating the wear of an arms with a view to prevent crime, was there ever any description of that? What did that part mean?
It meant nothing. What it was a ploy to let the legislature do whatever they might want to. And there's a Latin term for that called sua sponte. It means just because they want to. And so that's what we've got as a legislator acting sua sponte against the right of the people when they know that that is an abrogation of their oath of office, which says that they will do nothing that would appear injurious to the people's ability to enjoy the rights and privileges enumerated in the Declaration of Rights. And I would think that if you read the Declaration of Rights, if you actually knew a little bit about what it said, that all this malarkey we've had on there since 1801, here's the fact. 1796 is when we ratified. Well, we didn't ratify. In fact, the Constitution was so great that when they carried it to Washington for the federal government to look at, they didn't even make us come back and do a ratification vote. They admitted us into the Union forthwith. Thomas Jefferson said of our Constitution that it was the least imperfect and most Republican of the state documents. He said that about our 1796 Constitution. Now, if in fact that is the case, and we know it's a fact because the Secretary of State's got it on his website, and he acts like it's really an important thing to him that our Constitution was so good that we were admitted into statehood automatically for it. But here's the other side of that whole thing. If that Constitution at that point was so great, in 1796, it said that the citizens have a right to keep and bear arms for their common defense. How come in 1801 the General Assembly passed the first law that made it a crime to carry a handgun? Yeah. And they've been doubling down on that ever since. In 1821, it got worse. In fact, in the Bruen case, the attorney arguing for the other side against the Second Amendment rights used Tennessee as a poster child. He said, why, if Texas and Tennessee can say that it's a crime for you to carry a handgun, why can't New York? And that just burned me alive that they were able to take my state and use me as a poster child for gun control, not for gun liberty, like everybody moving in here from Illinois and Florida and California think, oh, we're moving to a free state. It's red. More people there voted for Trump than anybody else. And yet it's still a crime in Tennessee for you to carry a firearm for any purpose except hunting. Right. And you got to have a license then to do that.
Yeah. And your carry permit it's a mitigating factor. Essentially,
it is. It's an affirmative defense against prosecution of the crime, which is still on the books. And so the only time you get to raise that is before the trier of fact, and that is either a bench trial and a judge or a jury. And then if you can prove to them that you do in fact have your handgun carry permit, then they say, oh, well, then just the mere carrying of a firearm wasn't a crime. Better give him the stuff back and let him go home. But you've already spent a night in jail and had to get an attorney to come help you, and you lost a day's work, and your wife's mad at you because you were in jail for whatever reason. I mean, what's the use of that in a state that's supposed to be the patron state of shooting stuff?
I don't know. I don't understand it. I was shocked to hear that we had restrictions going back to 1801. That was really hard to believe.
Well, it's not hard to believe at all because the legislature wants to have the power. You need to understand, you've heard a number of times when you read back through all the documents coming from the founders, they talked about select militias and standing armies and how dangerous they were to liberty.
Right.
Well, you need to understand that the state police and the sheriff's department are simply select militias because they're able to carry any firearm that they want to. Pretty much every squad car in Tennessee right now has got an M4 select fire machine gun in the back end of it that you and I are purchasing for them. And they're of recent manufacture. They can carry them, but we can't. And we had to buy them and pay for them to tote them, but we can't have them for our own defense. What are the chances with the numbers that we have right now, pretty much across the board, depending on the district that you're in, there is one post-certified law enforcement officer on duty for every 7,500 people
Wow.
What are the chances that individual is standing next to you when a crime occurs? I mean, if you live out in the county where I do, you're looking at 19 to 20 minutes for a response to a 911 help call.
Right. Right.
But what are you supposed to do in that 20 minutes that it takes for them to get there? Say, please, Mr. Criminal, don't harm me or steal my stuff or kill me or rape my family. What? It's Jeff Cooper said this years ago, if you want to stop crime, criminals don't fear the courts. They don't fear the police. They don't fear jail.
Right.
If you want to stop violent crime, what you have to do is to make them fear their victims.
Yeah.
And so the only way they're going to fear their victims is if they got that ability to put firearms into use to protect them. I don't remember exactly. I should have prepared for this question, I guess, but there were over 2 million uses of firearms by individuals last year told us by the FBI. Now, think about that. If the police are being all powerful to stop crime, why would 2 million people need to use firearms in their own self-defense?
Yeah, they definitely don't like to tout that number either. That's not, I mean, it's in the report, but it's definitely not broadcast. That's not something the news is letting us know about, or even our state. They're not, saying, hey, here's how many times people were able to defend themselves and prevent themselves from being a victim of crime. That's just not something they put out.
And the FBI put out something just a little bit ago, too, that if I'm not mistaken in the way I recall this, is that when private citizens use firearms in a situation where there was an active shooter, they were 40% more effective than police officers at the time in stopping that threat.
Wow.
Now, that tends to fly in the face of everything that they tell us, that only professionals need to be using firearms. That's not true.
Nope.
And so across the board, the whole point of this case is it's simply unconstitutional for you to say that it is a crime for me to carry a firearm. The mere possession of having a firearm is a crime in Tennessee. When our Second Amendment, and you have to understand the Second Amendment analog, was patterned after the Second Amendment of the federal Constitution at that time, because that was already in place, right? Yeah, it took the 10 amendments being ratified by the states before they'd ever ratify the Constitution. And so they had to put that out there to all the states to make sure those rights of every American were safe. They were taken away from the ability of government to steal them from you. And yet what we've got in Tennessee is government has reached in and stolen those rights away from us.
Yeah. Well, and if you look at the preamble to the Bill of Rights, it was pretty clear that the states did not want to recreate what they just fought against. And so really the Second Amendment was about the states being able to defend themselves from a tyrannical federal government more than anything.
That is correct. George Washington has said a number of times that the reason for the Second Amendment in our Constitution was to keep the government in awe of the people.
Right.
Now, think about that. If George Washington, who was the father of our country, and everybody thinks it's just the best thing since sliced bread, said that, then why isn't it true right now?
Because we don't have enough people in office that think that, and we don't have enough people out of office putting pressure on the ones in office.
That's true, sadly.
At the state level, and Tennessee's got the Declaration of Rights. I got a little pocket copy here, and this is really for the audience. You can get these from your legislator, but you're going to have to ask for them. Have your state rep or your state senator give you a bunch of these little booklets and pass them out, because it's got the Declaration of Rights right up front. That's the first thing in the Tennessee Constitution is Declaration of Rights. It's right there, and it lays out all the power. It's very similar to the U.S. Constitution, but everybody should be familiar with this, especially your Declaration of Rights. And in fact, it talks about the Section 26 is the analog to the Second Amendment in our Tennessee Declaration of Rights. And then later on, I think it's Article 11, Section 16, miscellaneous provisions.
Yeah.
where it
The one that
says,
says that the Declaration of Rights hereto annexed is declared to be a part of the Constitution of this state and shall never be violated on any pretense whatever.
Yep.
And to guard against transgression of the high powers
Yep.
that we have delegated, we declare that everything contained in the Declaration of Rights is held out of the general powers of government and shall forever remain inviolate.
so how many people in the legislature do you think really understand our right and or really support it? You don't have to name names, but you can give me numbers.
I would say that there are probably 5 in the House and maybe 3 in the Senate.
Wow.
I mean, that's an honest appraisal. After 30 years of walking the halls up there and knowing the players, they don't care.
Yeah.
I mean, your highest guys in the caucuses of both of them absolutely refuse to entertain that those are rules that are placed on them. Yeah. Because here's the way they look at it, to be quite honest. Anything they pass and can get the governor to sign is constitutional until TFA or GOA or NRA comes in and spends 10 years and $500,000 suing them over it. And they get to enforce whatever they want to put on the books until such time as that can be accomplished. And now, even though we've gone to court and sued them and it's been declared unconstitutional, they've got their rugby scrum together and they decide we're just not going to pay any attention to a duly constituted court of law. And here's the thing, in their motion for emergency stay, the state said that procedurally the trial court had erred. But when the appellate court came down with the agreement on their emergency stay, they didn't give a reason for it whatsoever. And it should have been required of them to put in a brief why they chose to uphold that, when the actual brief against the stay was so perfectly done. If anybody hadn't read that, you can go to the TFA website and you can look over on the right-hand side, and there are all these articles that we put up, and you can actually read the motions from the state and from the opposing team, GOA, and you can tell me which one of those you think is more prudent, which one is more correct, which one is more constitutional. When they talk about the fact that, well, you know, we admit, this is what the Attorney General said, we admit that as a state, the enforcement of these statutes at time has been unconstitutional. But what we perceive is that it limits our police power to do whatever we want to. There's that sua sponte thing again. We don't care what the people require. We don't care what the Constitution says. It's just because we want to that we're going to continue to fight this, and we're going to use our power over the appellate court to get them to issue an emergency stay until such time, maybe 2 years from now, they take up the case again. I mean, we've asked for an expedited review and to bring this thing to closure, but that don't mean we're going to get it.
Yeah, I'm sure it's not going to happen. Yeah, it won't happen in an election year.
No.
Everything will be dead this session. It's not going to happen this session, I'm sure.
And here's what the legislators say. Oh, well, this didn't need to go to court anyway. We should have. This needs to be handled by the legislature because we're the one that make laws. Well, we've had a Republican supermajority for at least the last 13 years now.
Yep.
What are they waiting on? It's not like we have not raised the issue. I have been at the Capitol a number of times, yep. And in the last 6 years, we've tried to pass this thing 3 times,
right.
And it never gets out of committee.
Yep.
One of the two in the ping pong game that the Senate and the House play, yep. Where if they've got enough people in the Senate, which have got primary contenders, they're going to be the Second Amendment faithful, and so they'll pass my constitutional amendment.
Right.
The resolution and send it to the House, and they'll kill it out of hand, never even pick it up. They didn't open the book to see what it said. They just killed it because it's a Second Amendment friendly bill, and we don't want to have nothing whatsoever to do with it.
And what makes it so bad, too, is they do it with our money. They're using our money against us.
Absolutely, they're using our money. And I can't tell you because they won't tell me, because I've tried to find out, and I will probably issue a FOIA request to see if I can't find out exactly how much money the governor and the attorney general have spent in defense of an unconstitutional edict since this case was filed. And it's been 2.5 years since it was originally filed till we came out with this order. And now it's going to appeal, and it'll probably be another 2 years. Because what'll happen now is they'll try it in the House. I can promise you. There will be an individual who is trying to gain prominence and stature. He's going to carry a bill in the House to fix every bit of this as much as they want fixed. And it'll pass out of the House. Everybody will champion that. They'll get together and raise the flag. Oh, yes, we love the Second Amendment. And then what'll happen, it will get to the Senate, and the Senate Judiciary Committee over there is going to look at it and say, wait a minute. There's an open lawsuit about this. We can't do anything until that's been taken care of. And so we're going to send it to summer study. And so what they'll be able to do over the House has got trouble this year because they passed a bunch of numbskull stuff over there, and people are not happy with their House members. And so what they'll try to do is to gain redneck prominence by passing something that does away with this Jim Crow law like we've been saying we need to do all along. And they know that there's no chance it's going to get out of the Senate. And if it got there, the governor wouldn't sign it. You'd have to override a veto, which, by the way, is not difficult.
Yeah, it's pretty easy in Tennessee.
The same number of people to vote the same way they did the first time. And you override it. Because the governor's supposed to be the weakest link in our government.
But you would...
By design of our Constitution.
But you would think the way they kiss his butt that he's the most powerful. It's ridiculous up there. Well, the governor wants this, or the governor don't want that. And he just shuts things down. And I'm like, why don't they put that governor in his place?
Here's what it says in our Tennessee Constitution, Article 3, Section 10, that the governor's only job is to faithfully enforce the laws of this state. Now, it says in 11, he can from time to time send suggestions to the legislature about things that he thinks are important, but it doesn't mean he gets to write legislation, and he doesn't get to send all of his minions running over there to testify. Oh, well, our department, and we speak with the voice of the governor, we are philosophically opposed to allowing you to have the ability to exercise all the rights contained in the Declaration of Rights, whether that be the Second Amendment, freedom of speech, your freedom to raise your child, the freedom to educate your child as you see fit. All of these things that are in the Constitution as your right, the right to conscience, the right to be able to decide whether you want to take a vaccine or not, all those things that are in our Declaration of Rights, state governments just walked right over the top of you and done whatever they wanted to because they got more brown shirts and guns than we do. They're willing to use them, and we're not.
I don't think they got more, but they just got more that are willing to use them under the color of law. So predictions for, you think there can be anything worthwhile Second Amendment Section 26 past this upcoming session? Is there anything positive?
I think in the House, absolutely, that you'll see a movement to do what's supposed to be the right thing. And it won't be the right thing. It'll be somewhat close to it, just in case the Senate trips and fails in their usual acumen to say, well, there's an open lawsuit, so we can't do anything till that's decided, which is what's going to happen. You can mark my word on that right now, that the House will pass it and the Senate will kill it.
Well, and I don't doubt that. They play that game, and I don't doubt that. That's going to happen with the intent to carry. But like I know in the past, some of the other legislation has been, for instance, like being able to defend your property defend your property using deadly force. I know we've had that. Is that going to come back or?
I think it will be rerun again. I talked to Kip Kaplan the other day, and he intends to run it in the House. And I know Joey Hensley will probably run it in the Senate. But what will happen, if we can't get Paul Rose and Todd Gardenhire to quit voting with the Democrats, we're not going to be able to move that out of committee because they voted on both issues, allowing long guns back into the permissible class of weapons last year. And Rusty Grills has been trying to pass this now for 4 years, and we tried before that, but they just, no, that's a bridge too far. That's what Todd Gardenhire said. He didn't like that because somebody used a shotgun and scarred his nose with it at some point. I don't understand what that's about, but I did an actual interview with him and asked him about that very bill, and he said, look over here behind me. You see that shotgun? I keep it loaded and ready to go all the time. And then when that bill came to his committee, he said, no, I'm going to vote no. That's just a bridge too far. I don't think that's the right thing. And then he told the story about being accosted with a shotgun. He didn't talk about the guy that used the shotgun to accost him, but I suspect that if it had been a car that had run over him and the guy was trying to kill him, he probably wouldn't have wanted to ban cars for everybody in the state of Tennessee.
And I could understand how somebody would want to butt stroke that guy. I'll tell you what. If you ever, with the butt of the weapon, I could understand how somebody would want to do that to that guy. He just kind of brings out the worst in a lot of people.
Well, and then you've got Paul Rose, who is over here from Covington, that you would think, and he always says this, he's the president of the Second Amendment Butters Club. He says, I really support the Second Amendment, but I can't see allowing people to carry AR-15s in the Walmart. Well, I talked to a sheriff from Kentucky about 8 weeks ago, and I said, now, you live in Kentucky, right? Yeah. Do you ever go to Walmart? All the time. I said, have you ever seen anybody carrying an AR-15 in a Walmart? Well, no. I said, could they under Kentucky law? I said, well, absolutely they could. He said, but it gives away the fact that you're armed because most people want to carry them under their clothes, so they're not first target. I don't agree with that because if that was the deal, you'd have undercover police officers everywhere instead of squad cars with badges and uniforms on.
Right.
If it was so dangerous to carry a firearm, those police officers want to get home tonight. By the way, ask any one of them, anyone that is honest with you, why he carries a gun, and he will tell you to get home to his family at night. It ain't to protect you because he owes no duty to provide safety or security for any individual.
Right.
He's supposed to arrest lawbreakers when somebody tells him they are and to generally keep the peace. And you can look it up and see what the order to a sheriff and his deputies and all police officers are in Tennessee. There is nothing that said you will protect the individual because they can't. Right. They're covered by qualified immunity. And by the way, I think this is a very important thing to understand for law enforcement and DAs, assistant attorney generals across the state, district attorney generals, I should say. If, in fact, they try to enforce 3917, 1307A, or 3911A, they're putting themselves at a loss of qualified immunity because they're actively engaged in a civil rights violation. And therefore, the people are not going to defend them with our money when they get sued for that. That's going to be a personal thing for them. And I think that the ones that are smart are going to look at this and say, wait a minute, if, in fact, this were to fall on the other side of this, from what the state wants, I could be putting myself at risk for enforcing an unconstitutional law that's already been said is unconstitutional.
So the county sheriffs can make that call. The county sheriffs.
Yeah, they absolutely. Yeah. The sheriff is the chief constitutional officer in every county. He's got more power than the governor because he can at any time call out the militia in his county.
Right.
Most people don't understand that when it says he can call on as many of the citizens of that county to help him maintain order as necessary. And what are we supposed to do? We're supposed to have weapons, and we're supposed to be trained, and there used to be sufficient in what we're called to do when we're called up by the sheriff. And if you don't know how to use a gun, if you don't have a gun, how can you be fulfilling your obligation to the state?
Good question. I think, I think we really need to bring back the actual militias. I think the National Guard is a perversion of what was intended. I think it goes around what they initially intended to create because it gives the federal government too much authority.
The National Guard is federalized.
That's right.
Is you go to the Army for your basic training and all that. Yep. So it's not a militia. A militia is everybody.
Right.
I mean, you go back and you look at what they said in Georgia in the Nunn v. State case down there, and they said, well, the Second Amendment means that every person, every man, woman, child, girl, boy, it doesn't make any difference, needs to be carry any arm they want to. Because if you're going to have a militia that is efficient and can be used as it needs to be for the protection of the state, then the people have to have the arms and the training to be efficient. I mean, look at Heller. When Scalia was talking about it there, he said, to be as efficient today as militias were in the 1800s, a person would have to carry M16 rifles and such, arms that are not usual at this point, but are effective for the use of a soldier. And then you look at what Tench Cox said, that the sword and every terrible implement of the soldier are the birthright of an American, because we had to shoot our way out of tyranny. And they wanted to be sure that their progeny had the same ability to do the same thing in case the government that we installed over the ashes and dead bodies of the ones that was there before, we had the opportunity to maintain the control to say what was delegated to the servants that we need to run government. They're not our masters. They are our servants. And they've all forgotten that. They want to be our bosses. So sponte to do it just because they want to.
Yeah. And we've allowed it. Over the years, we've allowed it. Of course, there's a lot of people don't even realize. They think, oh, well, whatever the federal government says, that's what we have to do. And that's one of the big problems. Any closing thoughts?
The situation is thus. I'm hopeful that the DOJ, you've seen them, they just sued Hawaii.
Okay.
Harmeet Dillon, who is in fact the person in charge of the Civil Rights Division of the Department of Justice, is on a tear against states which are violating the tenets of the Second Amendment. She went and testified the other day. She wrote an amicus brief in the Chicago AR-15 and magazine ban. She showed up personally to argue that. She filed a suit this week against Hawaii where they said, well, you have to get permission from a store owner. You don't have to just wait and see if they got a sign saying you can't carry there. You have to affirmatively get permission from them before you carry a handgun inside a store. This is all balderdash. And so she sued the state. The Department of Justice sued the state for that. They're involved in the New Jersey AR-15 ban, and I'm hopeful that they would look at this mess that we've got going on, where even though the Attorney General has admitted to enforcing unconstitutional laws, he wants to do it anyway. It reminds me of Red Skelton. He looks around and says, if I do it, I get a spanking. And then he reflects for just a minute and says, but I do it anyway. So that's what they've got. They know it's unconstitutional, but they're going to do it anyway.
And they'll keep doing it until we can stop them somehow. The TennesseeFirearms.com is the website. A lot of great information on there. A lot of great information. I think you have podcasts on there as well, right?
I do. I do quite a number of shorts. If you go to our YouTube channel, you find our videos, and on there you find my little shorts and my other things, interviews with a lot of the legislators. And what you do is you put them on the camera, and then you hold them accountable after they change their ways.
Right.
They promise one thing when they're trying to get elected, and they do another once they are elected. And that's just so patently obvious there. But if you'll watch the videos, you get to see a real life portion of that in the videos that I do, because I try my best to get all of them. I will be doing an interview with Monty Fritz for governor. I will be doing an interview with John Rose for governor, and I have not even received an answer to the questions that I gave to Marsha Blackburn. And so that's what we try to do, is put the information out there to the voters. And here, I will say one last thing in closing. Last year, there were 758,000 hunting licenses sold in the state of Tennessee.
Wow.
If every one of those persons was a TFA member, we could do whatever we wanted to.
That's a good point.
But people just think they've got great gun laws in Tennessee. They don't realize that when they pick up that Dove shotgun and a box of shells and walk across a public road to get to wherever they're going to hunt, they just violated the law. They're committing a crime, because it is an offense to carry a firearm with the intent to go armed. And Elizabeth Stroker, who is the legislative director for the Department of Safety, testified in Senate Judiciary Committee when Gardenhire asked her what that meant. She said, if you got bullets for it. So it's okay for you to carry a shotgun and not have any ammunition. But then what if you go David Crockett and use it by the barrel to swing it like a club? It's also against the law to carry a club with the intent to go armed. So I don't think they know what they're talking about. And they certainly can't enforce the laws across the board, because they don't have a clue what they put in there.
Yeah, we have way too many laws. Way too many laws. And way too many lawyers. Any upcoming events?
we just had our annual, so that's out of the picture. I've actually got John Rose coming in this month, and Jackson, he's going to be our featured speaker on the 16th. So if anybody wants him, we had Monty Fritz last month. We're going to have John Rose this month. And if Marcia would decide she wanted to come down and get in front of the rednecks, then it's open to her too. The invitation's been sent. We're trying to get as many of the politicos in front of the people as possible so they can make good advised choices on who they elect.
Right.
And of course, we've got the 7th tomorrow.
Yep.
That's going to be very interesting to see how that plays out. Can Tennessee be bought once again?
Yeah. Yeah.
Which is the way I perceive it. And if so, then we know that that's a fact, that it doesn't make any difference whether you've got good quality candidates. It just depends on how much out-of-state money you can bring in to shore them up.
Yeah, and that should be flat out illegal. I don't know why we even allow out-of-state money into our elections. That's just wrong. Well, hey, thank you for being with us, and thank you for all you do. I know you're up there a lot. I've seen the pictures. You know, when you surrounded by all the commie mommies by yourself in a committee room, and I do appreciate it.
One last thing I will mention, I have started a new website, and for anybody that is used to the tame portion of what I do on our TFA websites, because we are under the auspices of the federal government with 501c4 and a 501c3, and we have to stay true to our mission statement. The new website is called pissedoffpatriot.org, and I don't have to play by any of those rules there. So that's just been put up. It's just come online, and I'm just now getting my arms around how to manage it and what to do. But there will be a lot of stuff coming out of that as well. So that's something. And my Substack, see Richard Archie at Substack.com. If you want to really be informed on the topics of the day, read my Substacks. And I put them out 1 or 2 every week or so.
Yep.
And they stay current with the topics that are in front of us on Second Amendment right now, because it's called The Truth of the Second Amendment in Tennessee.
Yeah, there's a lot of good information in that, a lot of good information. Well, hey, thanks again. Thanks for all you do, and we'll definitely have you back on.
All right. Thank you so much.
I want to thank the audience for taking the time to watch our program tonight. It doesn't cost anything to subscribe, so please be sure to hit the like and subscribe buttons as well as the notification bell so you never miss an episode. We appreciate your support. Thanks again to Jonathan and Mary for their financial support for the month of July, August, September, and now October. You guys are great. We really, really appreciate it. Check out our audio podcast on iHeartRadio, Spotify, and other platforms as well. Sign up for our weekly newsletter at our website, teeninformer.com. Find and follow us on Facebook and Twitter. A few announcements. The Stewart County Sons of Confederate Veterans will host Gene Andrews on October 14th, 7 p.m. at the Stewart County Visitor Center for a discussion on Nathan Bedford Forrest and the true story of the so-called Fort Pillow Massacre. It was not a massacre. You're going to get some truth if you show up and listen to this one. You'll enjoy it. And another announcement, the Henry County GOP will host a meet and greet for Monty Fritz, who is running for governor in 2026, on October 23rd, 6 p.m. at Tom's Pizza, 2501 East Wood Street. Please arrive early if you intend to eat. And the Stewart County GOP will host a meet and greet for Monty Fritz on October 30th, 6:30 p.m. at the Stewart County Visitor Center. If you have not heard Monty speak, you need to hear it. For our second show tonight, 8:30 p.m., Monty Fritz joins us to talk about his first month on the campaign trail and the response he has gotten. And we'll also have a second guest in the second show. This will be James Simpson, author of the book Manufactured Crisis, The War to End America. He'll join us to cover more details of the book that we were unable to cover last week. We had him on last week, a lot of great information. That's a very good book, a lot of info, but it's not a huge book. It's like 400 pages. So we're going to cover a little bit more of that tonight. Next Monday, October 13th, Tennessee Firearms Association Director and Attorney John Harris will join us to talk primarily about the amount of power possessed by your local DA, all for ill or good. And of course, we'll hit some of the AG and legislative actions against the right to keep and bear arms as well. For our second show next week, the regional director of the John Birch Society, Arthur Hampton, will join us. He'll explain who John Birch was and what they believe and what they fight for. It's a very good organization. They cover a lot of topics and they put out a lot of good information. So you'll want to hear that. There's a lot of misinformation out there about them as well. So he's going to help clear a lot of that up. Hope you can join us. That's it for now. Good night from Paris. Tennessee, that is.